Chapter 19, Manslaughter. Section 342, Definition. Classification. Manslaughter is the unlawful killing of a human being, without malice aforethought, express or implied. Manslaughter is divided into the following two classes: 1. Voluntary, and 2. Involuntary. Section 343. Voluntary manslaughter. Voluntary manslaughter is an intentional homicide committed in sudden passion caused by a reasonable provocation, and without malice aforethought. If upon a sudden quarrel two persons fight, and one of them kills the other, this is manslaughter, and so it is, if they upon such an occasion go out and fight in a field, for this is one continued act of passion, and the law pays that regard to human frailty, as not to put a hasty and deliberate act upon the same footing with regard to guilt. So also if a man be greatly provoked, as by pulling his nose, or other great indignity, and immediately kills the aggressor, though this is not excusable se defendendo, since there is no absolute necessity for doing it to preserve himself, yet neither is it murder, for there is no previous malice, but it is manslaughter. Section 344. Nature and requisites of voluntary manslaughter. The basis of the mitigation in this crime is the fact that the law takes cognizance of the frailty of human nature. 3. The true nature of manslaughter is, that it is homicide mitigated out of tenderness to the frailty of human nature. Every man, when assailed with violence or great rudeness, is inspired with a sudden impulse of anger, which puts him upon resistance before time for cool reflection, and if, during that period, he attacks his assailant with a weapon likely to endanger life, and death ensues, it is regarded as done through heat of blood or violence of anger, and not through malice, or that cold-blooded desire for revenge which more properly constitute the feeling, emotion, or passion of malice. For to constitute a homicide voluntary manslaughter, three things are essential: the killing must be done intentionally. 2. Malice aforethought must be absent. 3. A reasonable provocation for the act must exist. Section 345. Intention to kill must be present. In voluntary manslaughter there is always an intent to kill, either express or implied. When there is actual intent to inflict great bodily harm and death results, the intent to kill is implied. It is sometimes erroneously stated, however, that to constitute manslaughter the homicide must be unintentional. The presence or absence of intent to kill is not the feature which distinguishes murder from manslaughter, and an instruction which charges the contrary is clearly erroneous. Whether the homicide amounts to murder or to manslaughter merely, does not depend upon the presence or absence of the intent to kill. In either case there may be a present intention to kill at the moment of the commission of the act. When the mortal blow is struck in the heat of passion, excited by a quarrel, sudden, and of sufficient violence to amount to adequate provocation, the law, out of forbearance for the weakness of human nature, will disregard the actual intent and will reduce the offense to manslaughter. The presence or absence of intent to kill, however, is a distinguishing feature between voluntary and involuntary manslaughter. In the latter crime intent to kill is always absent, whereas in the former it is always present. Section 346. Malice aforethought must be absent. The thing which characterizes and determines the nature of a homicide is the quo animo, or state of mind, which accompanies the act, and not the act itself. That which distinguishes manslaughter from murder is the absence of malice aforethought. It is to be observed, however, that malice aforethought and intent to kill are not synonymous terms. To constitute a homicide voluntary manslaughter, absence of malice aforethought and presence of intent to kill are both essential. Section 347. Adequate provocation essential. To reduce a homicide from murder to voluntary manslaughter there must be adequate provocation. As a general rule, provocation is adequate when it is such as to induce an ordinarily reasonable man, in sudden anger, to take life. Ordinary human nature is the standard unless the accused person is shown to have some peculiar weakness of mind or infirmity of temper, not arising from wickedness of heart, or cruelty of disposition. The line of demarcation, however, between what constitutes adequate provocation and what does not cannot be exactly defined. It may be said generally that the distinction is between those provocations which ordinarily cause a great degree of resentment and induce violence, and those which are slight and trivial, ordinarily not followed by violence. Provocation to be adequate should be real, or so apparent as to justify the assumption of its reality. It should also be sudden and sufficiently great. It should be calculated to exasperate both in its character, and in respect to the persons against whom it is directed. Section 348. Malice implied when acts barbarous. When the punishment inflicted is far in excess of the provocation given, and under the circumstances outrageous, the law implies that it emanates from a malignant and cruel heart rather than from human frailty. Thus, where a young man asked a crippled old man 80 years of age impertinent questions, to whom the latter replied, "None of your business," and the young man, whose feet were shod with heavy boots, knocked the old man down with his fist and brutally kicked him so that he died. It was implied that the slayer possessed a cruel and malignant heart, an act which might constitute adequate provocation when done by one's equal in physical prowess, might fall short of being such when done by a cripple, a child or a woman. Violent acts of resentment, bearing no proportion to the provocation or insult, particularly where there is a decided preponderance of strength on the part of the party killing, are barbarous, proceeding rather from brutal malignity than human frailty, and barbarity will often imply malice. If, even upon a sudden provocation, one beats another in a cruel and unusual manner, so that he dies, though he did not intend his death, yet he is guilty of murder by express malice. Section 349. Nature and scope of the emotion engendered. Strictly speaking, it is not the provocation which reduces a homicide from murder to manslaughter, but rather the state of mind produced by the provocation. If the state of mind which caused the killing was not produced by the provocation but a cooling time intervened, then the killing is not manslaughter. The passion, or state of mind, essential to render the homicide manslaughter must be sufficient to rebut the imputation of malice. But, to accomplish this end, it is not essential that the reason be dethroned and the power of volition destroyed. The state of mind produced by the provocation must be such that the violence of the excitement impedes the exercise of judgment, and renders the slayer accountable as an infirm human being. A transport of passion, which deprives of the power of self-control, is, in a modified or restricted sense, a dethronement of the reasoning faculty, a divestment of its sovereign power, but an entire dethronement is a deprivation of the intellect for the time being. In the latter case the state of mind of the slayer would render him wholly innocent of crime. Section 350. Coexistence of passion and malice. Passion and malice may both exist in the mind of the slayer at the time of the act. In the eye of the law, however, they cannot coexist as the moving cause of the homicide. In other words, the law presumes that the killing cannot proceed from both impulses. Either one or the other must be the dominant motive which characterizes the crime. Malice is presumed from the act of killing, while, on the other hand, proof of adequate provocation neutralizes or overcomes this presumption. In other words, when the weight of the provocation is equal to, or greater than, that of the presumption of malice, the provocation is adequate to reduce the killing from murder to manslaughter. Provocation, however great, never disproves malice. The most it can do in any case is to overcome the presumption of malice. A malicious killing, however, no matter how great the provocation, is always murder. Section 351. Passion, or state of mind, must emanate from the provocation. The state of mind which the law recognizes as sufficient to reduce a voluntary homicide from murder to manslaughter must emanate from an adequate provocation. In other words, the provocation must be the direct and controlling cause of the excited condition of the mind at the time of the act. Passion which is not produced by provocation is insufficient, and when produced by provocation the law requires it to be sufficient to render the slayer incapable of cool and deliberate reflection. Section 352. Provocation of illegal arrest. A homicide, though unintentional, committed in resisting a lawful arrest is murder. On the other hand, it is often said that even an intentional homicide committed in resisting an unlawful arrest is manslaughter. As a general rule this is true. It should be observed, however, that there are exceptions to it. But, ordinarily, when the attempted arrest is illegal, as where the warrant is void, or the person making the attempt to arrest does so without a warrant, or without the officer's jurisdiction, the killing of the officer in resisting the arrest, whether done intentionally or otherwise, is manslaughter. The unlawful attempt in such cases usually regarded by the law as a sufficient provocation to reduce the killing from murder to manslaughter. Section 353. Illegal arrest, not a justification. An exception. An attempted unlawful arrest will not, as a very general rule at least, justify a killing. The attempt to take away one's liberty, while it may be imposed by the imperfect defense, cannot be resisted to the death. Nothing short of an endeavor to destroy life or inflict great bodily harm will justify the taking of life. Prevails in this case. The reason why a man may not oppose an attempt on his liberty by the same extreme measures permissible in an attempt on his life, appears to be because liberty can be secured by a resort to the laws. But there are cases where the party whose unlawful arrest is attempted may resist even to taking the wrongdoer's life, as where the attempt is to convey one by force beyond the reach of law, or to carry him out of the country. Section 354. Illegal arrest. When the killing constitutes murder. Ordinarily, as heretofore stated, an attempted illegal arrest is a sufficient provocation to reduce a homicide from murder to manslaughter. It is to be observed, however, that the killing must be done in sudden anger, and by reason thereof, however great the provocation, if the killing results from a malicious and cruel heart rather than from heat of blood, the homicide is murder. To render the homicide manslaughter, the proof must show that the killing, though intentional, was not the result of cool, deliberate judgment and previous malignity of heart, but, on the other hand, solely the result of sudden passion imputable to human frailty. In other words, it must be shown that the slayer was transported by ungovernable passion and deaf to the voice of reason, and that this state of mind was produced by inadequate provocation. Thus, where two men who had committed a crime killed the party who attempted to arrest them, not in sudden anger or heat of blood, but, conscious of their guilt, in order that they might escape just punishment, it was held that the homicide was murder and not manslaughter, even though the attempted arrest was illegal. Section 355. Illegal arrest, the slayer a felon. Upon principle, it would seem that when a felon, conscious of his guilt, intentionally kills a person who attempts to arrest him, and the proof shows that the person attempting to make the arrest is without legal authority, the homicide is murder. A sense of guilt cannot arouse honest indignation in the breast, and therefore cannot extenuate a cruel and willful murder to manslaughter. In the case of a felon there is much less cause for his reason to be disturbed or obscured by passion than exists in the case of an innocent person. In the felon's case the homicide results from the exercise of judgment, whereas in the case of the innocent person it results from passion. Section 356. Illegal arrest, the slayer a third party. A third party may lawfully interfere to prevent an illegal arrest. In the eye of the law such an arrest is a provocation not only to the person arrested but also to bystanders. And if a bystander, without malice, kills another to prevent him from making an illegal arrest the homicide is manslaughter. Section 357. Homicide which results from mutual combat. Ordinarily, a homicide which results from mutual combat is manslaughter and not murder. This is owing to the fact that in such case the killing is regarded as done in the heat of blood rather than maliciously. When, however, the proof shows that the slayer began the affray with intent to kill his adversary, or do him grievous bodily harm, the homicide is murder. Where two persons meet, without any previous intention of quarreling, and, suddenly, angry words pass which lead to blows, and in the heat of blood one of them seizes a weapon and inflicts upon his adversary a mortal wound, the homicide is manslaughter and not murder. In such case, it is immaterial who strikes the first blow, and also whether the instrument which is used is a deadly weapon or not. If a quarrel ensue between two persons and one strikes the other, and the latter attacks the former with a knife and severely wounds him, and the wounded party immediately kills his adversary, the homicide is held manslaughter. Moreover, previous encounters between the parties, even when malicious, and threats by one against the other, do not raise a legal presumption of malice in the subsequent encounter. As said by Hawkins, certainly, where two persons have formerly fought on malice, and are apparently reconciled, and fight again on a fresh quarrel, it shall not be intended that they were moved by the old grudge, unless it so appears from the circumstances of the affair. To constitute a mutual combat there must be mutual intent to fight and at least one blow struck. Section 358. Homicide which results from husband's knowledge of wife's adultery. In an early English case it is said that when a man is taken in adultery with another man's wife, if the husband shall stab the adulterer, or knock out his brains, this is bare manslaughter, for jealousy is the rage of a man, and adultery is the highest invasion of property. Courts then hold that the husband must have discovered the adultery on the spot, or must have ocular inspection of the act, and only then. For the husband to kill his wife on suspicion that she had committed adultery, however well founded, or upon hearsay, was murder. Modern decisions, however, upon this question, are in conflict. Some adhere to the old rule, while others take a more liberal view. Upon principle, the latter view is correct. The law accepts human nature as God has made it, or as it manifests itself in the ordinary man, and every sort of conduct in others which commonly does in fact so excite the passions of the mass of men as practically to enthrall their reason the law holds to be adequate cause. In harmony with the better view, it has been well said that since the law, as other sciences, makes progress, it is no longer accounted necessary that a husband should have ocular inspection, etc. It suffices if the provocation be so recent and so strong that the husband could not be considered at the time master of his own understanding. So where the evidence tended to show the commission of adultery by the deceased with the defendant's wife half an hour before the assault, the defendant seeing them go to the woods under circumstances tending strongly to impress an adulterous purpose on his mind, followed them, saw them come out together, and pursued the deceased toward a saloon and on the way was told that deceased and his wife committed adultery in the woods the day before, and defendant in great excitement entered the saloon and shot deceased, such evidence was proper to the issue of provocatio, and from it the jury might have found defendant guilty of manslaughter only. Section 359. Adultery, reasonable belief of wife's guilt sufficient to reduce a homicide from murder to manslaughter. Actual guilt on the part of the wife is not essential. Apparent guilt may be sufficiently strong to constitute adequate provocation. If the homicide is committed in a transport of passion upon discovering the decedent apparently in the act of adultery with the wife of the accused, under circumstances such as to induce and justify a reasonable belief on the part of the accused that such a crime was in progress, and there is no proof of actual malice, the offence is manslaughter only, although it subsequently turns out that adultery was not in fact committed. Section 360. Illicit intercourse with slayer's sister or daughter. Whether illicit intercourse with the slayer's sister or daughter constitutes sufficient provocation to reduce the homicide to manslaughter depends upon the circumstances of the particular case. In England the court determines whether certain acts constitute adequate provocation and the jury determines whether the provocation caused heat of blood which resulted in the homicide. And this view has been held in this county. According to the better view, however, the existence or non-existence of adequate provocation in such a case is a question for the jury to decide. Where a father slays a man who has ravished his daughter, the provocation may reduce the offence to manslaughter. Section 361. Insulting words and gestures. As a general rule, insulting words, however opprobrious, and gestures, however contemptuous, do not constitute a sufficient provocation to reduce a homicide to manslaughter. There are, however, exceptions to this rule. Special circumstances may render words alone sufficient. For instance, if a husband suddenly hearing from his wife that she had committed adultery, and he having had no idea of such a thing before, were thereupon to kill his wife, it might be manslaughter. In some states, statutes have been passed expressly making insulting words, under certain conditions, adequate provocation. Section 362. Trespass upon property. Insufficient provocation. A mere trespass upon property, other than the habitation, is not a sufficient provocation to reduce a homicide to manslaughter. Upon this point the decisions are in accord. If one man be trespassing upon another, breaking his hedges or the like, and the owner, or his servant, shall upon sight thereof take up an hedge stake and knock him on the head, that will be murder, because it was a violent act, beyond the provocation. It is a rule of law, that where the trespass is barely against the property of another, not his dwelling house, it is not a provocation sufficient to warrant the owner in using a deadly weapon, and if he do, and with it kill the trespasser, this will be murder, because it is an act of violence beyond the degree of the provocation. It is to be observed, however, that when the killing is done by an instrument not a deadly weapon, and in a manner not likely to kill, the homicide is manslaughter. Moreover, when a trespasser is opposed by force barely sufficient to prevent him from committing a trespass, a deadly weapon not being used, and during the encounter the trespasser is killed to save the other party from death or serious bodily harm, the homicide is excusable. If, however, the killing is not to save the other party from death or grievous bodily harm, but results from passion caused by the other's blows, the homicide is manslaughter. And if the killing is done maliciously it is murder. Section 363. Homicide resulting from a duel. When two persons, pursuant to an agreement, fight a duel, each bent on killing the other, and death results, the homicide is murder, notwithstanding the fact that the combat was conducted fairly. Section 364. Reasonable cooling time. Inadequate provocation reduces a homicide to manslaughter, provided a reasonable cooling time does not intervene between the provocation and the killing. But if the blood has a reasonable time in which to cool, the killing, notwithstanding the provocation, is murder. Actual cooling of the blood, however, is not the test. As a general rule, if, under all the circumstances attending the homicide, a reasonable length of time intervenes between the provocation and the act, within which under like circumstances an ordinarily reasonable man would cool, the homicide is murder. The law, in extending its indulgence to human frailty, does not look merely to the fact that the act has proceeded from the violent impulse of anger, outstripping the tardier operations of reason, but asks whether the anger has been provoked by sufficient cause and whether it has been made to yield to reason within a reasonable time. It regards men as rational creatures and expects them to subject their passions to reasonable control. Many decisions hold that the question of reasonable cooling time is one of law for the court to decide. Upon principle, however, the court should define to the jury the principles upon which the question is to be decided and leave it to them to determine whether the time was reasonable under all the circumstances of the particular case. Section 365. Involuntary manslaughter. Definition, essentials. Involuntary manslaughter is the unintentional killing of another person, without malice, but without excuse or justification. Its general requisites are as follows. 1. The killing must be unintentional. 2. It must be without malice. 3. it must be unlawful. Involuntary manslaughter may arise from an act of malfeasance or misfeasance, or from nonfeasance. Section 366. Homicide arising from acts of malfeasance. A homicide which arises unintentionally from the commission of another crime may be murder or manslaughter, depending upon the circumstances of the case. When a homicide arises from the commission of, or an attempt to commit a felony, such as robbery, rape, burglary or arson, or an act which naturally tends to cause death or grievous bodily harm, the killing is murder. This is owing to the fact that in such cases malice is implied. On the other hand, when it arises from the commission of, or attempt to commit, a misdemeanor, or an act malum in se as distinguished from an act which is merely malum prohibitum, there killing is manslaughter. Section 367. Homicide arising from assault and battery. When a person commits an assault and battery which falls short of having a natural tendency to cause death or grievous bodily harm, and a homicide unintentionally arises therefrom, the killing is involuntary manslaughter. This is true if the death is occasioned merely by fear or terror. Section 368. Homicide arising from a prize fight. When two persons engage in a prize fight, which constitutes a breach of the peace, and one unintentionally kills the other, the homicide is manslaughter. In a state, however, in which prize fighting is lawful, the unintentional killing of one of the contestants by the other would be excusable homicide. While, on the other hand, where prize fighting is a felony, the homicide, according to the common law rule, would be murder. Moreover, under this principle, to constitute the killing murder it is not essential that the act intended be such as to endanger life or threaten grievous bodily harm. The mere fact that the killing grows out of an act which constitutes a felony is sufficient. It has been held that a homicide arising from the commission of a robbery where the killing is done in attempting to escape with the booty, is murder. Section 369. Homicide arising from playing football. When several persons engage in a game of football, in a manner such as to be dangerous to life or limb, and one of the players unintentionally kills another, the homicide is manslaughter. Moreover, the fact that the game is played according to established rules is no excuse. On the other hand, when the game is played in a lawful manner, and one of the players is killed unintentionally, the homicide is excusable. For, in such case, the act is lawful, and the effect is merely accidental. Section 370. Homicide arising from correction of a child, pupil or apprentice. When a parent corrects his child, teacher his pupil or master his apprentice beyond the bounds of moderation, and death unintentionally arises from the undue chastisement, the homicide is manslaughter. If, however, the chastisement is within the bounds of moderation, the homicide is excusable. Section 371. Homicide arising from a riot. When a number of persons engage in the commission of a riot which results in an unintentional homicide, the killing is manslaughter and not murder. This is owing to the fact that riot, at common law, is only a misdemeanor. Section 372. Homicide arising from an unlawful attempt to procure an abortion or from unlawful intercourse. When a person unlawfully attempts to procure an abortion, in a manner not to endanger life or inflict serious injury and the woman dies, the homicide is manslaughter. When, however, the act is done under circumstances, or in a manner which endangers life or inflicts serious injury, and the woman dies, the homicide is murder. Where one raped a child and gave her venereal disease, from which she died, there may be conviction of either manslaughter or murder. Section 373. Homicide arising from an act which is merely malum prohibitum. To render a person criminally liable for an unintended result, the act from which it arises must be at least malum in se. Hence, where it is merely malum prohibitum he is not criminally liable for such result. Thus, where a person, while driving at a speed prohibited by a city ordinance, but not recklessly, runs into another, he is not criminally liable for assault and battery. Nor would he be liable for felonious homicide if the person run into were killed. And where a person, while carrying a concealed revolver in violation of law, accidentally discharges it and kills another, he is not liable for felonious homicide. Or where hunting game on another's land in violation of statute, he unintentionally without negligence kills another and such hunting is not in itself dangerous to life. Section 374. Homicide arising from a mere tort. When an unintentional homicide arises from a mere tort the killing is excusable. As said in a leading English case, the mere fact of a civil wrong committed by one person against another ought not to be used as an incident which is a necessary step in a criminal case. Section 375. Homicide arising from acts of misfeasance. A homicide which arises unintentionally from the doing of a lawful act in a grossly negligent manner is involuntary manslaughter. There are many cases in which death is the result of an occurrence, in itself unexpected, but which rose from negligence or inattention. How far in such cases the agent of such misfortune is to be held responsible, as a general rule depends upon the inquiry, whether he was guilty of gross negligence at the time. What constitutes gross negligence depends upon the circumstances attending the particular case. Thus, driving a team of horses, riding a bicycle or running an automobile at a certain speed, may be lawful and proper on a country road while grossly negligent on a city street. Section 376. Homicide arising from shooting at a target. A homicide which arises from shooting at a target may be excusable or felonious. Its nature depends upon the circumstances attending the act. If, under the circumstances, proper precautions have not been taken and shooting at the target constitutes gross negligence, the unintended homicide resulting therefrom constitutes manslaughter. Thus, where several persons engage in shooting at a target, and the bullets cross several highways and go in the direction of a habitation, as a result of which a boy in his father's garden is unintentionally killed, the homicide is involuntary manslaughter. Moreover, since all engage in the common pursuit, all are criminally liable. Section 377. Homicide arising from snapping a revolver at another merely to frighten. A person who snaps a loaded revolver at another, honestly believing that it is not loaded, or, if possessing knowledge that it is loaded but honestly believing that it will not go off, and intending merely to frighten the other party, shoots and kills him, is guilty of gross negligence and liable for manslaughter. Where one carelessly fires a pistol at the ground and the bullet glancing kills a bystander, he is not guilty of manslaughter unless the death was a natural and probable consequence of his act. In such case, the following instruction correctly states the law: if the defendant used a dangerous and deadly weapon, in a careless and reckless manner, by reason of which instrument so used he killed the deceased, then he is guilty of manslaughter, although no harm was in fact intended. Section 378. Homicide arising from turning a vicious animal where it may injure someone. If a person has knowledge that a certain animal is vicious and dangerous, and turns it out where there is danger that it may injure someone, and it attacks and kills a person, he is guilty of manslaughter. Section 379. Homicide arising from negligent operation of automobile. Where one willfully drives an automobile in a public street at a speed or in a manner expressly forbidden by statute, and thereby causes the death of another, on with reckless disregard for the safety of others, so negligently drives his automobile in a public street as to cause another's death, he is guilty of manslaughter. This principle was also applied in a case where a passenger was thrown out by reckless driving and killed. Section 380. Homicide arising from treatment or operation by physician or surgeon. When a physician or surgeon, in treating a patient or performing an operation upon him, causes his death by gross negligence, he is guilty of manslaughter. Consent of the patient is no defense. Thus, where a practicing physician, on being called to attend a sick woman, prescribed that her clothes should be kept saturated with kerosene, as a result of which treatment she died, he was guilty of manslaughter. It has been held, however, that when a licensed physician, or even a person who assumes the character of a physician whether licensed or not, through ignorance administers medicine which causes the death of the patient, with an honest intention and expectation of a cure, he is not guilty of felonious homicide. Such was the view of Lord Hale. 94. But, as said by Justice Holmes, Lord Hale himself admitted that other persons might make themselves liable by reckless conduct. We doubt if he meant to deny that a physician might do so, as well as anyone else. He has not been so understood in later times, and many modern English cases are in harmony with Justice Holmes' view. Section 381. Treatment or operation by physician. Bishop's view. From the relationship of physician and patient, the death of the latter not unfrequently arises. On this subject the doctrine seemed to have been held that whenever one undertakes to cure another of disease, or to perform on him a surgical operation, he renders himself thereby liable to the criminal law, if he does not carry to this duty some degree of skill, though what degree may not be clear. Consequently, if the patient dies through his ill treatment, he is indictable for manslaughter. On the other hand, a more humane doctrine is laid down, that, since it is lawful and commendable for one to cure another, if he undertakes this office in good faith, and adopts the treatment he deems best, he is not liable to be adjudged a felon, though the treatment should be erroneous, and, in the eyes of those who assume to know all about this subject, which, in truth, is understood by no mortal, grossly wrong, and though he is a person called, by those who deem themselves wise, grossly ignorant of medicine and surgery. The former doctrine seems to be the English one, and so in England a person, whether a licensed medical practitioner or not, who undertakes to deal with the life or health of people, is bound to have competent skill, or suffer criminally for the defect. Now, if a man thinks he has competent skill, and makes no misrepresentation to his patients concerning the amount or kind of medical education actually received by himself, he seems in reason to stand on exactly the foundation occupied by every person who honestly undertakes medical practice after full advantages, so far as concerns his state of mind, and it is the mind to which we look in questions of legal guilt. Any person undertaking a cure, but being grossly careless, and thus producing death, is for a different reason liable to a charge of manslaughter, whether he is a licensed practitioner or not. Section 382. Homicide arising from nonfeasance. A homicide which arises from a mere nonfeasance may constitute murder, manslaughter or excusable homicide. The nature of the killing depends upon the circumstances attending the particular case. Section 383. The duty omitted must be a legal one. To render a person criminally liable for a homicide which arose from nonfeasance, the proof must show that he neglected to perform a legal duty which he owed to the deceased. Omission to perform a merely moral duty is not criminal. Thus, where a mother omitted to procure the aid of a midwife for her emancipated daughter during child birth, in consequence of which neglect the daughter died, the mother was not criminally liable because the duty she omitted to perform was not a legal one. Section 384. Homicide arising from willful omission to perform legal duty constitutes murder. When a person owes to another a legal duty, and is willfully and inexcusably negligent in failing to perform that duty, as a natural consequence of which the person to whom he owes the duty is killed, the homicide is murder. Parents are under a legal obligation to provide food, shelter and medical attendance for their children, and if they willfully neglect so to do, and their children die as a result, the parents are guilty of murder. The same principle is applicable to a switchman in the employ of a railroad company. If he willfully omits to adjust a switch, thereby causing a collision of trains which results in the death of one or more passengers, he is guilty of murder. Section 385. Homicide arising from gross negligence. When death is caused by gross negligence, the homicide is manslaughter. The principle involved has been recognized in a great variety of cases, including the following, where, through gross negligence, a person discharges a revolver and kills another, or a physician in treating a patient causes his death, or a switchman causes a collision of trains resulting in the death of one or more passengers, or the captain of a vessel fails to stop the boat to rescue a seaman who has fallen overboard and his omission results in the seaman's death, or the motorman of a streetcar fails to keep a proper lookout and his omission causes the death of a person, or a person gives intoxicating liquor to a child, in a sufficient quantity, owing to its tender age, to cause its death, or a person runs over another with an automobile, or vehicle of any kind, and causes his death, or a druggist unintentionally gives another a poisonous drug which causes his death, or a parent fails to provide food for his infant child, or a husband to provide food and medicine for his sick and helpless wife. It also applies in any other case where a person owes a legal duty to care for a helpless person. And whether he is to receive compensation for his services or not is immaterial. It is to be observed, however, that inability on the part of the accused constitutes a defense, provided he has reported the matter to the public authorities, where public aid to sick or helpless paupers is provided by law. Moreover, if the neglected person could have saved himself from death, the accused is not criminally liable. A person, engaged in operating a mine, who through gross negligence causes the death of another, is guilty of manslaughter. Thus, where an engineer, in charge of a steam engine used to draw up miners from a coal pit, left his engine in charge of an ignorant boy, who was unable to stop it, as a result of which the skip was drawn over the pulley and one of the miners thrown down into the shaft and killed, the engineer was guilty of manslaughter. The ground bailiff of a mine, whose duty it is to regulate the ventilation of the mine, and direct where air headings should be placed, who is guilty of gross negligence in omitting to perform his duty, thereby causing an explosion of fire damp which produces death, is guilty of manslaughter. Section 386. Homicide arising from omission to perform legal duty owing to religious scruples. A good motive is no defense to a criminal charge. It follows, therefore, that a conscientious belief in the faith cure, or religious scruples against the use of drugs, is no excuse for omitting to perform a legal duty. Medical attendance and remedies are considered necessaries, both in England and in this country, and a person who owes a legal duty to another to provide him with such, and who is able to do so, is criminally responsible for refusing because of conscientious religious scruples. There are cases, however, holding the contrary. The same principle is applicable where a person does not believe in the expediency of vaccination. His belief, in such case, will not exempt him from criminal liability for violating a statute which requires it to be done. Section 387. Homicide arising from negligence less than gross. As heretofore stated, to render a person liable for involuntary manslaughter he must be guilty of gross negligence. Where, however, his negligence falls short of being gross, the killing constitutes excusable homicide.